I watched the Department of Justice file a notification with federal courts in 7 states stating that the United States will no longer defend assault weapon bans as constitutional under current Supreme Court precedent. Not that the government disagrees with the policy, that the government can no longer argue these bans survive constitutional scrutiny. That notification was filed quietly, no press release, no announcement, just a procedural filing that changes the entire landscape of gun control in America. When the federal government stops defending a category of law, that law loses its most powerful institutional advocate. This follows from the Supreme Court's 6-3 decision in Bruin. The government must prove any firearm restriction is consistent with historical tradition. Modern policy preferences do not matter. Public safety arguments do not matter. What matters is whether the regulation has roots in how the founding generation understood the Second Amendment. 7 states currently have assault weapon bans: California, New York, New Jersey, Maryland, Massachusetts, Connecticut, Illinois. Each defines assault weapons differently, but the principle is the same. Semi-automatic rifles with certain features are prohibited. The AR-15 platform and similar rifles are the primary targets. These bans have existed for years, some for decades. Federal courts upheld them under the old framework that allowed balancing public safety against individual rights. Bruin eliminated that framework. Historical tradition is the only relevant question. An historical tradition does not support feature-based bans on commonly owned firearms. The Department of Justice knows this. Internal memos show senior attorneys reviewed historical firearm regulations following Bruin. They examined colonial laws, founding-era statutes, Reconstruction regulations. They found no analog to modern assault weapon bans. There were no laws in 1776 prohibiting firearms based on features. There were no laws in 1868 banning rifles for having adjustable stocks or pistol grips. The founding generation regulated who could possess firearms in limited circumstances. They did not regulate which firearms based on appearance. The AR-15 and similar rifles are not rare weapons. They are the most commonly owned rifles in America. Over 24 million AR-15 pattern rifles are in civilian hands. That represents 40% of all rifles sold in the past 15 years. When a firearm is that common, it is protected under Supreme Court precedent, establishing that the Second Amendment protects arms in common use. The government's legal position has become untenable. They cannot argue that these rifles are uncommon. They cannot argue that historical tradition supports feature-based prohibitions. And they cannot argue that the rifles are not protected by the Second Amendment when the Supreme Court has repeatedly stated that common use equals constitutional protection. So the Department of Justice stopped arguing. The notification does not concede these bans are unconstitutional. It states the United States is withdrawing as a defendant and will not file briefs supporting state laws. The federal government is stepping aside. That might sound like a technicality. It is not. When the federal government defends a law, it brings resources. States cannot match. The Solicitor General has institutional expertise. The Justice Department has access to historical research. And expert witnesses, state attorneys general lack. Federal participation signals the law represents national consensus rather than local preference. Without federal support, state assault weapon bans are now defended by state attorneys general who must independently prove historical tradition. And they are losing. Illinois faced judgment first. The Seventh Circuit upheld Illinois' ban in November 2023 by 2-1, but the reasoning was immediately criticized as inconsistent with Bruin. The majority relied on public safety arguments and mass shooting statistics, exactly the interest balancing Bruin prohibits. The dissenting judge wrote that the majority ignored Supreme Court precedent and substituted policy preferences. That dissent has been cited in 4 district court decisions in other states as the correct Bruin application. California's ban is before the Ninth Circuit. During oral arguments in December 2024, judges pressed the state to identify historical laws analogous to feature-based prohibitions. The state struggled. He cited laws disarming Revolutionary War loyalists, which judges noted targeted dangerous people, not firearm categories. He cited 19th century Bowie knife concealed carry laws, which judges noted were manner restrictions, not ownership bans. Observers reported it became clear the state could not meet its burden. Without the Department of Justice providing backup arguments or historical evidence, the state stood alone. New York's ban is facing similar pressure in the Second Circuit. Maryland's ban was preliminarily enjoined by a district court in October of 2024, with the judge writing that the state had failed to present any historical evidence supporting feature-based prohibitions. That injunction is currently on appeal, but the state is defending it without federal assistance. The pattern is consistent. States are being asked to prove something that does not exist. There is no historical tradition of banning firearms based on folding stocks, threaded barrels, or pistol grips. These are late 20th century regulatory inventions. Modern inventions without historical roots cannot survive Bruin, but the implications extend beyond assault weapon bans. The same constitutional logic applies to magazine capacity limits, which 9 states have enacted. If there is no historical tradition of restricting the capacity of arms, then capacity limits fail under Bruin. It applies to waiting periods, which 10 states impose. If there is no historical tradition of mandatory delays between purchase and possession, waiting periods fail. It applies to permit-to-purchase requirements, which 7 states maintain. If there is no historical tradition of requiring government permission before exercising a constitutional right, permit systems fail. Each of these regulatory structures is now constitutionally vulnerable, and the Department of Justice is not defending any of them at the federal level. The government's withdrawal from assault weapon ban litigation is not an isolated decision. It is part of a broader reassessment of which gun control measures can survive the historical tradition test. State officials are responding differently. Some are doubling down. California and New York will defend their laws regardless of federal support or adverse rulings. These states are preparing to fight alone and discussing responses if their bans fall. Others are preparing for collapse. New Jersey convened a working group to examine vulnerable provisions and explore alternative approaches. Connecticut held hearings on potential modifications to reduce constitutional vulnerability. But modification may not be sufficient. The core problem is not specific features triggering bans. The problem is banning commonly owned firearms at all. If the Second Amendment protects arms in common use and 24 million AR-15 rifles exist, any ban targeting them conflicts with constitutional text as currently interpreted. The only way to sustain these bans under Bruin would be proving the founding generation banned entire categories of commonly owned arms. That evidence does not exist. They regulated conduct. They regulated carry in sensitive locations. They regulated who could possess arms based on criminal conduct or incapacity, but they did not ban categories of arms based on features or popularity. This is why the Department of Justice withdrew, because continuing to defend assault weapon bans would require the government to make arguments that contradict Supreme Court precedent. And making those arguments would undermine the government's credibility in other cases where historical tradition genuinely supports the regulation being challenged. The timeline is becoming clear. Multiple cases are pending in appellate courts. Decisions are expected over 12 to 18 months. When they come down, at least some bans will be struck down. When the first ban falls, pressure on remaining bans will intensify exponentially. Once a circuit invalidates an assault weapon ban under Bruin, other circuits face a choice. Reach the same conclusion, creating consensus these bans are unconstitutional, or uphold their state's ban, creating a circuit split, forcing Supreme Court review. Given the court's clear direction in Bruin and consistent votes in subsequent emergency applications, the outcome is highly predictable. The 6-justice majority that decided Bruin remains intact. Justice Thomas, Justice Alito, Justice Gorsuch, Justice Kavanaugh, Justice Barrett, and Chief Justice Roberts all joined the opinion establishing the historical tradition standard. Those same 6 justices have voted consistently in emergency applications to block gun control measures that lack historical analogs. There is no indication that any of them have changed their position. If assault weapon bans reach the Supreme Court, they fall. The only question is timing. States with these bans are preparing for that reality. Some are drafting contingency legislation for alternative restrictions that might survive scrutiny. Some explore registration requirements rather than outright bans. Some consider age-based restrictions, prohibiting sales under 25 rather than prohibiting firearms themselves. But every alternative faces the same test. Is there historical tradition supporting this regulation? For most modern gun control measures, the answer remains no. I have watched regulatory structures collapse before, not in the Second Amendment context, in other areas where constitutional foundations shifted and decades of regulation suddenly became unsupportable. The collapse does not happen at once. It happens through cascading court decisions, each removing another pillar until the structure cannot stand. That cascade has begun. The Department of Justice's withdrawal removed the primary defender of these laws. State attorneys general defend laws they cannot justify. Federal judges choose between Supreme Court precedent and state policy preferences. Based on decisions being issued, judges are choosing precedent. Within 24 months, according to assessments from state officials familiar with pending litigation, at least 3 states will likely see bans invalidated. Within 36 months, that could reach 6 or 7 states, effectively eliminating assault weapon bans as viable gun regulation in America. The rifles will not suddenly flood the market. They are already in circulation. What will change is that residents of banned states will be able to legally purchase what residents of free states have been purchasing for decades. Manufacturers will be able to sell into markets that were previously closed. And the regulatory model that attempted to prohibit firearms based on features rather than function will be recognized as constitutionally impermissible. This is not a prediction of what might happen. This is a description of what is happening. The legal framework has shifted. The federal government has withdrawn its defense. State laws are being challenged under a standard they cannot meet. and courts are beginning to rule accordingly. The Second Amendment, as currently interpreted by the Supreme Court, does not permit the government to ban firearms in common use based on cosmetic features or policy preferences. That interpretation may be controversial, it may be disputed, but it is the law, and assault weapon bans cannot survive it.